Good morning, everybody, and welcome to our employment law update webinar for universities. It's specifically relevant, hopefully, to universities, of what's happened recently and what we expect to happen in the next few months. So if we can move on to the overview slide, please, Amy. So I'm going to start off by giving you an update on recent employment law developments, some guidance and some changes in the law. Then Katie Hurst is going to give you a case law update. She's going to focus on some COVID-19 cases, and there are quite a few of those coming through now. A lot of them are employment tribunal decisions, but we're expecting more case law. So it's interesting to see how those cases are developing and their relevance to higher education. And then finally, Bob is going to look at what's on the rise and what we can expect over the next few months, what the developments are in progress, and what things that perhaps have been stalled for a while are then going to take place perhaps next year. So hopefully that will then leave us a lot of time for questions. So the next slide, please. I'm going to look at 4 recent developments which I think are relevant to HE providers. So if we move on to the first one. So before the COVID-19 pandemic, I think very few of us, either in HR or employment lawyers, were used to the use of Section 44 and Section 100 of the Employment Rights Act 1996. They were rarely used, but they are now being used quite regularly for issues in relation to COVID. So just to clarify, Section 100 protects employees for providing that a dismissal is automatically unfair when the employee leaves, proposes to leave, or refuses to return to the workplace because they reasonably believe they're in serious and imminent danger and can't be reasonably expected to avert it. So that has been really relevant in relation to COVID-19, where employees haven't wanted to come into the workplace or have felt unsafe in the workplace and then have left. And if they've been dismissed because of that, they don't need 2 years service to bring an unfair dismissal claim. It's an automatically unfair dismissal claim. So that has been used, and Katie will come on, I think, to deal with at least one of those cases in due course. So that's Section 100. Section 44 protects in a similar way, but in relation to action short of dismissal. So if anything is an unlawful detriment and it's in relation to those issues that I've just talked about, then that will be an unlawful detriment, and employees have been entitled to bring a claim in relation to that in the employment tribunal. The change has been under the order that's listed there, which came into force on 31st of May. That has now been, protection has now been extended to workers as well as employees. So from your point of view, you need to think a bit more widely. As I said, the rights don't require any qualifying period of service. And the order amends Section 44 to provide both employees and workers with a right not to be subjected to any detriment for raising health and safety issues, for leaving or refusing to return to an unsafe workplace, or for taking appropriate steps to protect themselves where they reasonably believe they're in imminent and serious danger. So the relevant act must have occurred on or after the 31st of May in order to qualify for the protection, but it is an important extension of rights to workers, so not just employees. And I think we can expect to see these sections being used in the coming months in relation to COVID issues and employees not wanting, workers not wanting to return to the workplace. Can we move on to the next slide, please, Amy? So the second issue I want to talk about is gender pay gap reporting. And as you'll be aware, the reporting requirements were suspended for 6 months to support employers during the pandemic because of the continuing effects of the pandemic. So the deadline for public authorities would usually have been the 30th of March. It is now, the revised deadline is 5th of October. So next week you have to publish your gender pay gap report for the reporting year 2020 to 2021. I'm sure many of you have done that or have had them ready to publish already, but I just thought it was something worth highlighting today. Move on to the next slide, please. HEIs has produced some very useful guidance during the pandemic, and one of the useful pieces of guidance and advice that it published in May was in relation to long COVID. And as I think you will probably be aware, long COVID is becoming a real problem in the workplace. It has a variety of different symptoms and it can last for a long period or shorter periods. But ACAS published this advice because, according to the Office of National Statistics, over 1 million people have reported experiencing long COVID symptoms. So this advice lists the symptoms, and they can be, like I say, a variety of symptoms. Some can last weeks, some can last months. It's expected some may last over a year. So it's things like fatigue, shortness of breath, problems with memory and concentration, difficulty sleeping, joint pain, depression and anxiety. There's a full list of all the symptoms that are recognised at the moment in the guidance. And what the guidance says is that usual rules of sickness in your sickness policies for sickness absence and sick pay should apply to people who are off work because of long COVID. So that would apply in relation to your normal sick pay policies, what your normal sickness absence procedures dealt with in the same way, and if necessary, going down your ill health or capability procedure in the normal way if somebody is absent due to long COVID. The thing with long COVID, though, is, as with many other illnesses, it's not necessarily going to mean that somebody is off sick. It may mean that there are other impacts on the job, and ACAS encourages employees to discuss these with their employer. And then employers should consider how to support with long-term COVID. Usually, I would say, for universities with occupational health support. So it's things like flexible working, reasonable adjustments, what can be done to keep the person or help in the workplace or help them return to the workplace, and what support can be given. As I say, it depends on the particular circumstances how long and what the impact of long COVID can be. But there is the potential for it to be a disability if, in a particular case, if the impact is severe enough, and if the long COVID is expected to last 12 months or more. So I do think you need to be considering disability and possible reasonable adjustments, particularly if somebody has been had long COVID for a period of several months. You also need to be considering other discrimination issues. There's some evidence that it typically affects older people, people from ethnic minorities and women. So I think you need to be aware of other discrimination issues, age, disability, race, sex discrimination when dealing with these issues, and just take those into account when you're taking any decisions in relation to it. But I would say that this guidance, this advice is quite helpful and something that you might want to consider looking at if you haven't done so already. So if we could move on to my final slide for this section, please. And this is another ACAS publication. This is guidance on hybrid working. In June 2021, there was an ACAS survey, and 55% of employers said that they anticipated employees working from home at least some of the time, part of the week after the pandemic has come to an end. So this is about people splitting their time between the workplace and working remotely, be that from home or somewhere else, and provides useful guidance, which was published in July of this year. And I think it's particularly timely when I think a lot of universities, people who have perhaps been home working for most of the time, are now coming back in the new academic year onto campus, but perhaps splitting their time between campus and working remotely. The guidance talks about the practical implications, and it's supposed to help employers have discussions with employees about flexible ways of working, hybrid working, splitting time between the workplace and home. It suggests consulting with staff about these arrangements, or with employer representatives, or for universities, usually trade unions, about the introduction, the practical implications, to ensure things like regular communication, that the right technology is in place to ensure this can happen, things like performance management, and also health and safety. So those are the kind of things that are covered by the guidance. It suggests that employers might want to create a policy. I don't know whether any of you have created a hybrid working policy yet, but it is something that you may want to consider. Who's going to be eligible? There must be some roles that can be done in the workplace and remotely. There must be others that can't. People have to actually carry them out on campus in practice. Things like how can it be requested, and principles. Are there a maximum number of days that you will allow employees to work from home, or is it going to be depend on the particular circumstances? There are other issues to consider. There are things like ensuring that staff who are working remotely aren't excluded and have access to the same opportunities to those in the workplace. So we're talking about training and development and things like that, opportunities for promotion. Those are other issues that the guidance says should be considered. It says that all decisions ought to be fair and transparent, and other forms of flexible working besides just hybrid working should be considered. And Bob will come on to talk about what's been proposed in the last few days in relation to flexible working later on. Also says consider training for line managers and staff on managing hybrid working and the issues it raises, and also considering a trial period if that may be appropriate. Thanks, that's all I was going to talk about, and I'll now hand over to Katie for her case law update.
Thank you, Jane, and good morning, everybody. I'm going to talk about 3 cases today, all of which arise as a result of the COVID pandemic. The first case is one which relates to general unfair dismissal, and the second 2 are both, in fact, claims for automatic unfair dismissal under Section 100 of the Employment Rights Act, which is the one that Jane mentioned earlier. So essentially, cases where employees have claimed that their employer has put them in circumstances of serious and imminent danger. So we are seeing more of those cases, and these 2 examples are highlighting that fact. The first case, Cubilius and Kent Foods Limited. This is an employment tribunal decision where an employee pursued a claim of ordinary unfair dismissal. So the circumstances were Mr. Cubilius was a driver for Kent Foods, and one of the major customers for Kent Foods was Tate and Lyle. And in fact, from the depot that Mr. Cubilius worked, around 90% of the work that was done was for that particular customer, for Tate and Lyle. Tate and Lyle required face masks to be worn by all staff and visitors at its Thames site. This was early on in the pandemic, and they introduced that rule fairly quickly, I think. Mr. Cubilius was a driver, and there was a driver's handbook which clearly stated that customer instruction regarding PPE must be followed, and also that maintaining good relationships with customers and suppliers was an essential part of the job. Mr. Cubilius did carry out a delivery to one of Tate's sites on a particular occasion. As he arrived, he was given a face mask to wear, but he wasn't given any instruction as to when he needed to wear it. He, in fact, did wear it when he was outside of his lorry cab, but whilst he was sat inside his cab, he refused to wear the face mask. He said that his cab was his home and that wearing a face mask was not a legal requirement. So 2 employees of Tate had asked him to wear the mask whilst he was sat inside the cab, and he refused to do so. He was right in that it wasn't a legal requirement at that point in the pandemic to wear a face mask. But as a result of his refusal, he was subsequently banned by Tate and Lyle from their site. And of course, that materially affected his ability to do his job, because around 90% of the work was with that customer. Kent Foods carried out an investigation. In fact, I think it was a relatively straightforward investigation, because Mr. Cubilius accepted that he had refused to wear the mask whilst sat in his cab. But as I mentioned earlier, his rationale was that his cab was his home, and in fact there was no legal requirement to wear a mask in any event. The employer found that his refusal to comply with the instructions was basically something which amounted to gross misconduct, and they summarily dismissed him. So the question for the employment tribunal was whether that dismissal was fair or not. There were a few factors to think about before we come on to the decision. So first of all, he was given the mask, but he wasn't told when to wear it. Secondly, he did wear the mask when he was outside of the lorry cabin, but refused to wear it whilst inside. Thirdly, he'd been given a written health and safety policy when he arrived at the site, but that policy did not refer to wearing masks, presumably because it was a measure that had just been brought in sort of as a result of the pandemic, and therefore the policy hadn't been updated at that point. So the tribunal considered the circumstances, and they found that in fact his dismissal was fair. There were a few reasons why they reached that conclusion. So the first centred around the driver's handbook, which Mr. Kubilius was aware of, and he knew that there was an obligation on him as a driver to comply with a customer requirement to wear PPE, and also with maintaining good relationships with customers and suppliers. Secondly, the tribunal found that the disciplinary procedure had been fair. So the employer had carried out an investigation, it had held meetings with Mr. Kubilius and the individuals who had been at the site at the time, and it had reached a reasonable conclusion based on those facts. Another important factor was that, in fact, throughout the process, Mr. Kubilius continued to insist that he had done nothing wrong. He continued to insist that he was not required to wear the face mask, and obviously that caused some concern for the employer about what his future conduct might be in the same circumstances. Finally, it was also a big factor in the decision that in fact he had been banned from the Tate and Lyle site, and so carrying out his role had become pretty much impossible. Interestingly, the employer had tried to change the minds of the decision makers at Tate and Lyle, but they were adamant that they didn't want him back on site. And also the employer had considered whether they could redeploy Mr. Kubilius elsewhere, but given that most of the work was with Tate and Lyle, they were unable to do that. So the tribunal found that the dismissal was fair in those circumstances. So moving on to the next case, which is Akitatis and Fortuna Group Limited. So again, this is an employment tribunal decision, and it's a claim for automatic unfair dismissal under section 100 of the Employment Rights Act, so the health and safety grounds. The facts of this case are that Mr. Akitatis worked for Fortuna Group as a sales and marketing coordinator. Ironically, the company sells and distributes PPE. During March and April 2020, when the pandemic first hit, the claimant, Mr. Akitatis, repeatedly asked to work from home or to be placed on furlough leave, explaining that he felt uncomfortable using public transport and working in the office. The employer considered it, but told him that his job could not be done from home, and that furlough leave was not an option because the business was understandably extremely busy at that point. However, they did say that he could instead take holiday or unpaid leave. So they gave him that option of not coming in if he insisted that he didn't want to do that. He declined that offer, and he asked 3 more times to be furloughed. After his final request on the 21st of April, he was dismissed by email the same day. So he didn't have the sufficient 2 years service to bring a claim for ordinary unfair dismissal, and so he pursued a claim of automatic unfair dismissal, which you don't need the 2 years qualifying service for. So the question is, was his dismissal fair in the circumstances? And the two factors which the tribunal looked at were, in relation to the Section 100 claim, firstly, were there circumstances of danger that the claimant reasonably believed to be serious or imminent? And the second factor is whether the claimant took or proposed to take appropriate steps to protect himself or other people from the danger, or take steps to communicate that to the employer. So the tribunal found that the dismissal was in fact fair. It looked at the circumstances. It observed that the government had announced in February that COVID posed a serious risk to public health, and that together with Mr. Akitatis's emails expressing his concerns showed that he did reasonably believe there were circumstances of serious and imminent danger. So he'd succeeded on the first limb. However, he failed on the second point because he couldn't show that he'd taken appropriate steps to protect himself from danger, because in fact the employer had offered that he could take holiday or that he could take unpaid leave and therefore wouldn't be required to come into the office. However, his response was not only that he wanted to stay at home, but that he wanted to work from home or be furloughed on 80% pay, and the tribunal found that those demands were not appropriate steps to protect himself from danger. So the claim failed. So I think that case is a good reminder that the pandemic may not on its own justify a refusal to attend work if the employer has reasonably tried to accommodate concerns and take the appropriate steps to reduce the risk and the transmission. And then the final slide for me, please, Amy, thank you, is Gibson and Lothian Leisure. So this is another employment tribunal decision and another claim for automatic unfair dismissal under Section 100 of the Employment Rights Act. The circumstances of this case were that Mr. Gibson was a chef and worked at a restaurant which was owned by Lothian Leisure. The restaurant closed in March 2020 due to the first lockdown, and Mr. Gibson was furloughed. Before the restaurant reopened sometime later, the employer asked Mr. Gibson to come into work. However, he was concerned about catching COVID, and in particular passing it on to his father, who was clinically vulnerable and was shielding at the time. He raised concerns about the lack of personal protective equipment available and a lack of COVID secure precautions. And unfortunately, the employer's response was robustly negative. He was told to, quote, shut up and get on with it, which he objected to. So with no further discussion, the employer sent Mr. Gibson a text message dismissing him without notice at the end of May 2020. That text message also said that Lothian Leisure was changing the format of the business and would be running with a smaller team after lockdown, which suggested, in fact, that there was a redundancy situation. So the question here, was it a automatically unfair dismissal? In contrast to the case which we've just talked about, the tribunal found that this was an automatically unfair dismissal, and Mr. Gibson succeeded in his claim. The tribunal found that in relation to the first aspect, so whether he reasonably believed there were circumstances of serious and imminent danger, the tribunal found that Mr. Gibson did reasonably believe that there were circumstances of serious and imminent danger, in particular the potential harm that could be caused to his father, who was shielding. Secondly, in relation to whether he had taken steps to protect himself or another person, in this case, they found that Mr. Gibson's refusal to attend work were steps which he had taken to protect his father in this case, and that because he was dismissed as a result of that, the dismissal was automatically unfair. The tribunal awarded him notice pay and holiday pay also, as he'd been summarily dismissed. So again, it's a good case that helps to highlight the fact that we are seeing more of these Section 100 claims. And from an employer's perspective, I think it just reiterates the fact that there do need to be appropriate risk assessments, there do need to be appropriate policies in place, that those need to be kept under review and updated, and importantly, communicated to employees. And that should go some way to helping to show that there are no circumstances of serious and imminent danger presented to employees, and hopefully reduce the risk of claims to automatic and fair dismissal. So I'll now hand over to Bob to do the final section.
Thanks, Katie, and good morning, everyone. So in my section, I'm going to have a look at a few legal developments on the horizon and consultations as they affect the HE sector. So if we can look at the next slide, please, Amy. First of all, I'm going to have a quick look at the employment bill. The reason there's a question mark at the end of that is to reflect the degree of uncertainty as to when we're actually going to see primary legislation come into force, as it's been proposed for nearly 2 years now, and we don't have any specific time for the bill coming into law. Then I'm going to have a look at a couple of consultations. The first arises from one of the proposals in the employment bill and relates to making flexible working the default, and Jane's already mentioned that briefly. I'm going to briefly look at the Home Office policy announcement tackling violence against women and girls strategy, in particular how the DfE has been mandated to address that issue as it affects the university sector. Again, relatively briefly look at the hopefully imminent UK guidance on dealing with sexual misconduct. And then I'm going to finish by looking at proposals for mandatory vaccinations and how possibly the extension of mandatory vaccinations may affect the sector. I've mentioned the return of gender pay gap reporting on this introductory slide, but as James already covered it, I'm not going to go into that in any detail. So if we look at the next slide, just to look at progress of the employment bill to date, as it says on the slide, it was first mentioned in the Queen's speech in December of 2019. In March this year, the government confirmed it was not going to form part of the current parliamentary session, and there was no mention of it at all in the Queen's speech in May 2021. The Undersecretary for Employment has said that the government does still propose to introduce the bill when parliamentary time allows, but at present we've got no specific timescale for when that might happen. Just to remind you of some of the contents of the bill, if we have a look at the next slide, most of these arise from the Good Work Plan, which is the proposal that emerged from the Taylor report on working practices in the UK. The single enforcement body is a proposal to have a single labour market enforcement agency to better ensure that vulnerable workers are aware of and can exercise their rights, and which is intended to support business compliance. We haven't much more detail than that as to the nature of the body yet, but that's the current proposal. Pregnancy and maternity discrimination, the proposal there is to extend the current obligation to offer a suitable alternative employment to women who are pregnant or on maternity leave, to a period that starts with the day they inform their employer that they're pregnant and ends 6 months after return from maternity leave. So it's essentially a proposal simply to extend the time period within which the protection applies. The right to request a more predictable contract is part of the set of measures proposed in the Taylor report to remove uncertainty in the 0 hours sector of the workforce. And the proposal is to introduce a right for all workers to request a more predictable and stable contract after 26 weeks of service on 0 hours contract or a similar arrangement. There's two separate, I've bundled them into one bullet point here, but there are two separate proposals as regards additional leave. The first is a new right to neonatal leave and pay, which is intended to support parents of premature or sick babies. The second is a proposal for a week's leave for unpaid carers, which was actually made as part of the Conservative Party's election manifesto. And then the final two bullet points are actually both looking like they're not going to wait for the introduction of the full primary legislation, but may actually be introduced in other ways or in separate legislation. There is currently consultation on the introduction of legislation requiring tips and service charges to be paid to workers in the future. And finally, there has just been launched a new consultation on making flexible working the default position, which I'll go into in a bit more detail in the next slide. So if we move it on, please, Amy. So the current consultation was launched on the 23rd of September 2021. There was a point at which the government was considering a proposal simply to make to create an automatic right to work flexibly. The consultation document doesn't propose that. Instead, what it asks for feedback on is a suite of measures to broaden the scope of the right within the existing system. So, as you'll all know, currently employees or workers are required to have 26 weeks continuous service before they have the right to request a flexible working arrangement. One of the proposals made is to change that to a day one right, so that such a request can be made at the start of employment without any service requirement. There is a question in the consultation document about whether it's thought necessary to review any of the 8 reasons on which a request may be refused. The government has said that its views is that there isn't a need for fundamental change to those 8 business reasons, but it's seeking feedback from responses to the consultation document to see if there's any appetite for a review. One of the other main driving thoughts in the proposals is an idea that flexible working will work better if it is genuinely collaborative and flexible on both sides. And so the question is asked whether it would be of assistance to support that kind of idea, to require employers who reject flexible working requests to suggest an alternative. And the example that's given in the document is that if an employer can't accommodate a permanent change, perhaps it would be sensible for them to suggest a short 6-month temporary arrangement in its place. They also moot potential changes to the administrative process. Chiefly that's around things like timescales, so perhaps removing the limit on making one flexible working request in every 12 months, so that if an employee has a significant change in circumstances within a 12-month period, they can make a second request. And then there are general proposals around raising awareness of the existing right of employees to make flexible working requests. So, as I say, this is a consultation document at the moment. The consultation closes in October, and then we'll see what the government response is to the consultation. So it may be a fair way down the line at the moment, but that appears to be in train at least. So if we move on to the next slide, please, we'll look at the next consultation. So this has arisen as the result of a Home Office policy published on the 21st of July 2021. This is a wide-ranging Home Office policy document dealing with tackling violence against women and girls and setting out the government strategy for doing that. Of particular interest to the HE sector, though, is the section of the document which mandates that the Department for Education will work with the Office for Students to tackle sexual harassment and abuse in higher education, and it has been asked to review options to limit the use of NDAs in cases of sexual harassment in higher education. And obviously that will most impact those in the HR field when dealing with settlement agreements with employees who are either who have either brought allegations of sexual harassment or indeed are the subject of allegations of sexual harassment. We don't know anything about the DfE's proposals in this respect yet, but we certainly do know that there is a line of movement against the use of confidentiality clauses in settlement agreements already as the result of the #MeToo movement and the legislative and regulatory response to that. So you know, we'll all need to keep an eye on what proposals emerge from the DfE's review. Next slide, please, Amy. Also to flag, and I'm not going to say much more than what is on the slides, University UK updated its ZELIC report guidelines in October 2016, and I think not long afterwards indicated that it intended to produce guidance dealing with sexual misconduct in the higher education workplace. We did think that this might end up in Jane's part of the talk some time ago, because indications were that that guidance was going to be released in the spring of this year. It's not yet been released. We understand that it is in course and expects the UK expects to produce it relatively soon, but we don't have any kind of timescale on that. But of course, once those guidelines are produced, we'll all need to take care to see what recommendations and guidance emerges. Next slide, please. And so this is my final point, really. You will probably be aware, although I suspect not at the forefront of your day-to-day practice, but the fact that mandatory COVID vaccinations in the adult care home sector are coming into force in November 2021. This currently applies to any care home that is regulated by the Care and Quality Commission and requires its employees to be fully vaccinated in order to work in the care homes. It's not limited to employees. It includes any worker who is required to enter a care home in order to do their work, although not employees who work on care home grounds. So an example is given in the guidance that accompanies the new regulations of a hairdresser, a self-employed hairdresser who went into a care home in order to service clients there would be required to be fully vaccinated, but a gardener who worked on the grounds and didn't need to go into the building wouldn't. But otherwise, except for a variety of exceptions, like people providing emergency care, generally speaking, anyone going in for work purposes is required to be vaccinated. So far, not particularly relevant to the HE sector. And as I've mentioned on the slide there, our judicial review has recently been brought by two individuals, one a care home support worker and the other a care home program director, who from time to time is required to go into regulated care homes. And there's not a great deal of information about the judicial review proceedings yet, but the main basis of the challenge appears to be that they say that the mandatory vaccination policy is an unlawful infringement of their human rights. So there's at least in theory scope for that JR to succeed and for the regulatory requirement to be overturned. Subject to that, though, the Department of Health and Social Care has earlier this month published its consultation document on proposals, firstly, to extend mandatory vaccinations to other health and care settings, and secondly, to include an obligation to have a flu vaccination as well as two COVID jabs as a requirement to attend those care settings. The proposal talks about extending the obligation to anyone who is providing direct health or social care, and that would include in NHS hospital settings, in GPs, and in other primary care environments. And so that is has the potential to affect any of your students who are involved in health or care courses that have a work placement element to them. So quite possibly students studying medicine or nursing. There may well be other courses too. So it will be something for you to keep an eye on, and if the proposals go ahead, you'll have to consider how you may need to be involved, the extent to which you might have to become involved in managing those vaccinations. This is all relatively speculative at the moment, though, so this is just one to keep an eye on as the consultation progresses, rather than anything imminent. And finally, just peripherally on that point, we have recently been made aware at VWV that the Office for Students appears to be starting to ask higher education institutions for information about student numbers who are vaccinated. And we aren't clear how widespread the requests are now, but we have seen specific examples of the OFS asking universities to provide information about student vaccinations. And so we are circulating a poll asking those that we know in the sector to let us know whether they've received such a request, and what they're doing, in fact, to deal with collecting vaccination information, if anything. If you are on our higher education brief circulation list, you will have received the poll already. But I think we are going to send anyone who's signed up to this webinar a copy of it directly as well. We'd be very grateful if you take 5 minutes to fill it in and provide the information. And of course, if you participate, we'll provide you with the outcome, so you'll have a bit of an idea of how widespread the issue is in the sector. And of course, the more of you who participate, the better the data will be, and the more useful the poll will be. So please do take 5 minutes to fill it in. And that's the end of my section. So I think we can move on to the Q&A now.
Thank you, Bob. Just looking in the Q&A box, there don't appear to be any questions at the moment.
Covered it all so thoroughly
that
that nobody needs to ask us anything. That's good to hear.
There may be one in the chat.
Ah.
Yeah, here we are. We have a clinically vulnerable lecturer who we've agreed could solely teach online last academic year, who has said he needs to return to the workplace to deliver face-to-face teaching. He has said he will, and he attended the department away day last week. Since then, he has raised concerns about his safety, given other members of staff were not wearing face coverings or keeping at a distance. We strongly encourage this, but in line with government guidelines, do not enforce it. We want to give a firm message that all staff should return, but how can we protect ourselves for a possible Section 44 claim here?
Katie, do you want to have first stab at that? Would you like me to give my thoughts?
Yeah, go ahead, Bob.
Well, I think that the basics of this type of situation are always going to be relatively similar. It's all about the extent and quality of your communication with the individual about all of the steps that are being taken to minimize risk of COVID infection in his place of work, his or her place of work, which is easy to say, but of course, as with all of these situations, it's actually very difficult, and the devil is in the detail. I think to a relatively large degree, you are helped by government guidance now that clinically extremely vulnerable people are no longer required to shield and can go into the workplace. And I think that will have a fairly significant impact on assessments of whether the employee in question reasonably is concerned for a serious threat and imminent threat to health and safety. But I think the other side of this is that we are all in something of an unknown area. And so it's very difficult to say with any certainty where the boundaries lie. And certainly an employee who's in the CEV category is going to have better arguments about the reasonableness of their concerns for their health than just about anybody else. So process-wise, it's a matter of good communication, taking into account specific concerns that are raised, and doing what is possible to address them. And that might include a combination of measures to communication about measures to keep shared workspace areas clean, social distancing where possible, barriers if social distancing is not possible, proper ventilation, all of the things that would have formed part of your COVID health and safety risk assessment. But you know, there's certainly scope within your discussions to reach an impasse with the employer, and then that becomes a very difficult situation, and not one that I'd necessarily want to try and answer just in a webinar Q&A. But it's all about discussion, consultation, and trying to overcome specific objections rather than just a general position that I don't feel comfortable on campus. Jane or Katie, anything to add to that?
I was going to say that the other thing is, it was an away day. I can imagine that being less socially distanced than actually when carrying out a job itself. So that might have been a slightly more risky sort of scenario than the day-to-day. So maybe the day-to-day you'll be able to convince the individual that it is a safe environment.
Yeah, and I would just add that it's important to make sure that risk assessments are up to date, because obviously things are changing, maybe not week by week now, but certainly month by month. So making sure that that's up to date to account for the fact that, for example, masks don't have to be worn, and then communicating that, as Bob mentioned, with employees. Every case will be different, but that should go some way to showing that there isn't that serious and imminent danger.
Okay, Bob, there's one for you here. Have you a sense of returns to the OFS on the question of vaccination of students? We struggle to think of a good legal reason for asking the question to staff or students or retaining that data. Are we outliers?
Oh, yes, are we an outlier? I think the short answer to that question is no, I don't have a sense yet of returns to the OFS, but what we really hope is that by circulating this survey, we'll get some good quality data. And it's almost, I suspect, a little bit circular. So this first came to our attention last week, I think, for the first time. So we know that the OFS is starting to ask. We don't know how much it's starting to ask. And I suspect that my guess would be that most institutions are not collating the data yet. And for that same reason that the person who's asked the question has raised, what is the lawful basis for processing the medical data, which will be special category data, and therefore require express consent to process. It may be that the OFS, if the OFS requires institutions to collect the data, then there may be a regulatory requirement which presents a lawful basis for processing. So that, as I said, it could be the fact that they're asking that gives you the ability to ask for the data. But as I say, this first came to our attention actually through VWB's data protection support team for HEIs, last week, we are in the very early stages of formulating how we think HEIs should react, and we're hoping that the survey will help to inform our view, which we'll then share.